The Unfair Contract Terms Act 1977 is an Act of Parliament of the United Kingdom which regulates contracts by restricting the operation and legality of some contract terms. It extends to nearly all forms of contract, and one of its most important functions is limiting the applicability of disclaimers of liability. The terms extend to both actual contract terms and notices that are seen to constitute a contractual obligation. The Act renders terms excluding or limiting liability ineffective or subject to reasonableness, depending on the nature of the obligation purported to be excluded and whether the party purporting to exclude or limit business liability, acting against a consumer. It is normally used in conjunction with the unfair terms in Consumer Contracts Regulations 1999, as well as the Sale of Goods Act 1979 and the Supply of Goods and Services Act 1982. The Law Commission and the Scottish Law Commission have recommended that the unfair terms in Consumer Contracts Regulations 1999 and the Unfair Contract Terms Act 1977 should be replaced by a more unified and coherent regime. Terms rendered ineffective. Negligence. S2. Liability for negligence occasioning death or personal injury cannot be excluded. Manufacturer's guarantee. S5. Loss arising from defective goods or negligence of distributor cannot be excluded where goods are of a type ordinarily supplied for private use or consumption. Sale of goods. S6. Implied terms as to title cannot be excluded. S6. Implied terms as to description, quality or sample cannot be excluded against a consumer. Terms governed by the Consumer Protection Act 1987. They are also governed by the Occupier's Liability Act 1984. Terms subject to reasonableness. Negligence. S2. Exclusion of liability for negligence other than for death or personal injury must satisfy the requirement of reasonableness. Contractual liability. S3. This applies against a party that deals on standard written terms or where the other party deals as a consumer. Any exclusion by that party for liability arising from a breach committed by the party under the same contract, or performance under a contract, which is substantially or totally different of that which is reasonably expected of him, shall be void except insofar as it satisfies the requirement of reasonableness. Indemnity clauses. S4. A party dealing as a consumer cannot contract to indemnify a third party on behalf of the other party, except insofar as it satisfies the requirement of reasonableness. Sale of goods. S6. Implied terms as to description, quality and sample may only be reasonably excluded where neither party is dealing as a consumer. Misrepresentation. S8. Substitutes the Misrepresentation Act 1967 S3. Under that Post 1979 section, an exclusion of liability for misrepresentation must satisfy the requirement of reasonableness. Definition of consumer and business. S1. The Act only applies to liability for breach of obligations or duties arising from things done or to be done by a person in the course of a business, or from the occupation of premises used for business purposes of the occupier. S14 includes any government department. Consumer. S12. A party deals as a consumer if S12. He is not in the course of a business and does not hold himself to do so. S12. The other party is in the course of a business. S12. In sale of goods contract, the goods are of a type ordinarily supplied for private use or consumption. This subsection does not apply to individuals. S12. A party is not a consumer if dealing at an auction where he has the opportunity to attend in person or is not a natural person buying auction. S12. Burden is upon the party purported to be acting in the course of a business to show that either he is not in the course of a business or that the other party is otherwise not a consumer. Definition of reasonableness. Section 11 provides some guidance, but most development has been in common law. Schedule 2 gives guidelines specifically to SS 677. Common Law. Stuart Gill Limited v. Horatio Maranam Co. Limited provides that reasonableness is assessed at the time of contract, and that the burden of proof is upon the party purporting to have excluded liability. Leveson v. Patent Steam Carpet Cleaning Co. Limited provides that clarity and preciseness will raise the reasonableness of a term, and vice versa. See also Stagline Limited v. Tyne Ship Repair Group Limited as to small print. Smith v. Eric S. Bush. Lord Griffith provides 4 points that may be considered. Equality of bargaining powers. How practical was it to obtain independent legal advice regarding the term? How difficult is the task being undertaken for which liability is being excluded? What are the practical consequences of ruling that a term is unreasonable?